minutes. There are alternate paragraphs 6 through 10.
$24.
Yes.
Correct.
Mine's blank. You left me out.
No, use this one.
I think it may be the wrong, let's see.
Blank.
All right. Paragraphs 6 through 10 are optional paragraphs. Is either side requesting paragraph 6?
Not necessary.
That will be omitted. Is either side requesting paragraph 7?
Doesn't apply.
That will be omitted. Is either side requesting paragraph 8?
Yes, Your Honor.
That will be given with the pronouns he or she. Is either side requesting paragraph 9? Defense?
You said 9, Judge?
Yes.
No.
All right.
No.
Yeah, I don't think there was any record evidence that supported that, or paragraph 10, correct?
Correct.
All right, paragraph 10 will be omitted. Paragraph 8 will be renumbered paragraph 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court?
Would you rather put that person? Rather than he or she?
I think I'm just going to leave it generic as to the pronouns. Deals with questions from jurors during the presentation of evidence that did not occur in this trial, so I have omitted that standard paragraph, renumbered standard paragraph 8-7. On page 23, last paragraph under the heading, plea if not guilty, reasonable doubt, and burden of proof. I have amended the standard jury instructions in the following manner. If you have a reasonable doubt, you must find the defendant not guilty. I find that that's a more accurate recitation. Counts 1 through 5 are standard instructions listed out pursuant to the indictment. As to counts 1 through 5 in the jury instructions, are there any requested amendments or changes? State?
Just with respect to the lesser charge.
Yeah, we'll get there. As to the 5 counts on the indictments, any requested changes to those specific jury instructions? Defense? Thank you. All right, beginning on page 8 is a discussion of lesser included offenses. The required category 1 lesser included offenses of murder in the second degree and manslaughter will be given as to each counts 1 through 4. State additional argument as to the permissive category 2 lesser included offenses that are currently included in the jury instructions as to counts 2 regarding Alexander John Todt and count 4 regarding Megan Denise Todt. I have read the Humphrey v. State case, that's 690 Southern 2nd, 1351. Also read the case law that was provided by the defense. The record, that's Anderson v. State, 70 Southern 3rd, 611, and Lester v. State, 25 Southern 3rd, 623. Any additional case law you wish to present, Ms. Hicks? All right, thanks. Any additional case law the defense wishes to present regarding the category 2 permissive lesser included offenses? All right, thanks. Ms. Hicks?
With respect to count 2, which is Alex Road,
Yes.
I think the case law that the state presented to you basically lays out is that it's very clear that you are not entitled to non-homicide lessers unless there's sort of a special circumstance. I think the case law basically envisions sort of 3 possible circumstances. You have a circumstance where there is a deceased victim, there's no question that there is a deceased victim, and there's one person who is alleged to have killed that person. In that situation, you are not entitled to a non-homicide lesser. Then you have the situation where 2 people work together in principle scenario where the example I gave yesterday, I think in hindsight really wasn't a very good example. Because if 2 people are principals and they go to victim, what the principal instruction says, it doesn't matter who actually killed the victim, if the two people were working together to have that person die, then they are both principals to that crime, and it doesn't matter whose actions actually caused the death. And so in that situation, you would not be entitled to a non-homicide lesser because the two people were working as principals to achieve the same end goal, and there's no question about whether or not the victim is dead in that case. Then you have the third scenario where there's probably a number of factual situations where you could, this could come up. I think it goes often comes up in the situation where the person is dead. There's no question the person is dead. But that there's questions about how the person died. And so as you saw in the case law, it typically comes up where kind of like a law school exam. This happened, and this happened, and then this happened. What was the proximate cause of the victim's death? So in the example that we gave you, it was a punch, and then the guy falls, and then it's not until several days later he goes to the hospital, things happen in the hospital. And so there was a question about whether or not the punch actually caused the death.
And you're referring to the Anderson case and the analysis in the Lester case where those were analyzed as well as Humphrey.
So yes, so in this situation, look at this situation, I think one of the things that's very important to recognize is the defendant is not claiming any involvement in this. So this is not a situation where we have sort of that third scenario where he's saying, well, I did do something, but that didn't cause the defendant's death, the victim's death. And so it's very important to recognize that the defendant is claiming absolutely no involvement in any of these homicides. And so with respect to Alec, what you have is the state's what the defendant is not claiming that he was involved in the death in any way, shape, or form. And what the state's evidence shows, what the defendant said in his statement to law enforcement, is that Megan held Alec's legs while he stabbed and he suffocated Alec. In that situation, if, for example, Megan had lived and we were prosecuting both of them, they would be principals to the death. There's nothing that Megan did independent of what the defendant did that could have caused the victim's death. There's absolutely no record evidence of that third scenario, which is the only scenario that in any way ever supports getting a non-homicide lesser. So in this situation, the defendant either acted completely on his own, or the defendant and Megan caused the death of Alec together as principals. And so if Megan was still here, it doesn't matter whose actions actually caused the death if they were acting together to achieve the goal of causing Alec's death. And so with respect to Alec, there's no record evidence to support that they should get the non-homicide lessers. So that's my argument with respect to count 2. With respect to count 4, it is slightly different, but I don't think it actually changes the end result. It's obviously slightly different because again, the defendant is saying he had no involvement in Megan's death. And the court, with his defense here, he had no involvement in Megan's death. It's not as if he's saying, you know, I stabbed her and then she somehow ended up committing suicide. He's taking no involvement in any way, shape, or form. And so you have to, again, look at what are the actions that caused Megan's death. And the record evidence is that she stabbed herself. Those stab wounds were not independently fatal. And then he is the one that actually caused her death by suffocating her with a pillow. So again, you have a situation where two people were acting together. If you believe his statement to law enforcement, two people were acting together to achieve a common goal. It's a little different in this situation because the common goal is usually you see two people working together to kill a third person. In this case, you have two people working together to kill one of those two people. And so it is a situation where, again, they are principals in Megan's death to what happened to her. There's nothing independent that would result in getting one of the non-homicide arresters. The defendant is not claiming that he did anything.
I understand the argument. Thank you, Ms. Hicks. Defense? Any additional argument?
Your Honor, yesterday I was adamant, and today I leave it to the discretion of the court as far as the lessers and non-homicide lessers.
All right, I have reviewed the case law in this case, as in the Humphrey case. There is no doubt of the deaths of all four decedents. Either the jury, which is the finder of fact, is to determine the facts are that Mr. Todt had no involvement whatsoever based on his testimony in the deaths of all four of the individuals, or that he did have involvement in the deaths of one or more of the individuals, and then they are to make a determination as to whether that homicide was justifiable or excusable. The Humphrey case is very clear that the general rule is where homicide has taken place, the proper jury instructions are restricted to all degrees of murder, manslaughter, and justifiable and excusable homicide. Those would be limited to the required Category 1 lesser included offenses. The court cannot reconcile through the record evidence any reasonable view of the evidence that has been presented or reasonable inferences from the evidence that has been presented that would permit the court to give non-homicide permissive Category 2 lesser included offenses pursuant to the analysis in Humphrey. So the court is going to exercise its discretion as encouraged by the defense and remove the permissive Category 2 lesser included offenses from Count 2 and Count 4. The lesser included offenses that will be sent back for the jury's consideration are that of second-degree murder and manslaughter. Any additional requested changes to the jury instructions from the state? Any additional requested changes to the jury instructions from defense?
Yes, sir, not from what we've seen today.
Thank you. All right, I won't hold you to it, but how long do the parties anticipate needing for closing arguments?
A little more than an hour.
Defense?
Same.
Okay. All right, we're going to be in recess. I'm going to make the amendments that we have discussed to the jury instructions. I'm going to print out a proposed final copy of jury instructions. Those will be disseminated to all parties. We'll verify that the changes have been made that were discussed in the charging conference, and I will return at 10 o'clock. As previously announced, I intend to read up to the cautionary instruction upon the returning of the jury. That will give them instructions on the elements of the laws and the lesser included offenses. At cautionary instruction, I will take a break from the jury instructions and allow for closing arguments. After that, I'll return to the jury instructions, finish that off, send the jury off for their consideration. Ms. Pennell?
Judge, did you receive the proposed verdict form?
I did. Thanks. All right, the proposed verdict forms that I received contemplated the Category 2 lesser included offenses as to Alexander John Todt and Megan Denise Todt. Those will need to be amended to remove the Category 2 lesser included offenses, and if you'll send that over for the defense's consideration and send me a copy, I'll print those out and have those ready to go. I'll inquire as to all parties. I think I saw the exchange of a internet disabled laptop this morning. Ms. Smith, Mr. Wesley, Ms. Romero Sanchez, have you had an opportunity to review that laptop to ensure that it's not internet capable?
I did, Judge.
All right, thanks. Any objection to that going back when the evidence goes back for the jury's consideration?
No, Judge. I was speaking with the state. I didn't know. I know some judges do it differently in terms of what evidence they don't send back, in terms of what's been introduced. Some that has to be viewed in the courtroom versus some that doesn't. But leave that to the court.
I'm open to reasonable requests on any biological samples or anything like that if there's some concern about that. But
I think that's typically the only things that are of concern would be firearms, and firearms in this case, although there are the 2 knives. And then oftentimes the deputies have input into what they're comfortable with having going back. And then, of course, the biological stuff, sometimes we send it back. Well, if you do send it back, I would certainly send back gloves. The only thing that I maybe think that you might want to tell the jury is the defendant's interview is going to go back with you, but just remind them that the transcripts are not evidence, and so we might be able to avoid a question from the jury about, hey, we have transcripts, we have the audio.
understood.
Just the thought.
Yep. All right. Thanks. We'll be in recess until 10 o'clock. We are back on the record. Could I see the attorneys at the bench briefly? Mr. Todt, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to answer in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. Todt, I just have one question for you this morning. Do you believe that you were given a meaningful opportunity to participate with your counsel in the formulation of your jury instructions?
Yes, sir.
Thank you. Right. We have all our jury members?
Yes, Your Honor.
Let's return the jury, please.
All rise for the jury, please.
You may be seated. Thank you. Ladies and gentlemen of the jury, again, good morning.
Morning.
I'll be inquiring as to the same questions as always. The court had previously instructed each member of the jury not to discuss the facts of the case with anyone and not to conduct any independent research. If you have been able to agree or comply with this instruction, if you will please raise your hand. I see all hands. Thank you. Court also inquires whether anyone has been inadvertently exposed to any information about the case outside of the courtroom through the media or elsewhere. Has anyone found themselves exposed to any information outside of the courtroom by a show of raised hands? Court sees no raised hands. Ladies and gentlemen, both the state of Florida and the defense have now rested their presentation of evidence. I'm going to read some jury instructions to you. If you're a visual person like I am, I have included a courtesy copy of the same instructions for your consideration. I'm going to be taking a break from these jury instructions on page 20, and that will allow the parties to give closing statements if they wish to do so. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Statement of charge. Anthony John Todt, the defendant in this case, has been accused of the crimes of murder, first degree, murder, first degree, murder, first degree, murder, first degree, and cruelty to animals. Introduction to homicide. Anthony John Todt is accused of first-degree murder in counts 1 through 4. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Zoe Elizabeth Todt or Alexander John Todt or Tyler John Todt or Megan Denise Todt was killed by Anthony John Todt, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Anthony John Todt may be found guilty of first-degree murder or any lesser included crime. Count 1, murder, first degree, Zoe Elizabeth Todt. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Zoe Elizabeth Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was a premeditated killing of Zoe Elizabeth Todt. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 2, murder, first degree, Alexander John Todt. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Alexander John Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was a premeditated killing of Alexander John Todt. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 3, murder, first degree, Tyler John Todt. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Tyler John Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was a premeditated killing of Tyler John Todt. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 4, murder, first degree, Megan Denise Todt. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Megan Denise Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was a premeditated killing of Megan Denise Todt. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 5, animal cruelty. To prove the crime of animal cruelty, the state must prove the following element beyond a reasonable doubt. Anthony John Todt unnecessarily killed an animal, to wit, canine. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of the crimes are: as to count 1, murder, first degree, Zoe Elizabeth Todt, murder in the second degree, and manslaughter. As to count 2, murder first degree Alexander John Todt, murder in the second degree and manslaughter. As to count 3, murder first degree Tyler John Todt, murder in the second degree and manslaughter. As to count 4, murder first degree Megan Denise Todt, murder in the second degree and manslaughter. Lesser included offenses, count 1, murder first degree Zoe Elizabeth Todt, murder second degree. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Zoe Elizabeth Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was an unlawful killing of Zoe Elizabeth Todt by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or to do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Zoe Elizabeth Todt is dead. 2, Anthony John Todt intentionally committed an act or acts that caused the death of Zoe Elizabeth Todt, or Anthony John Todt intentionally procured an act that caused the death of Zoe Elizabeth Todt. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. Lesser included offenses, count 2, murder first degree Alexander John Todt, murder second degree. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Alexander John Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was an unlawful killing of Alexander John Todt by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Alexander John Todt is dead. 2, Anthony John Todt intentionally committed an act or acts that caused the death of Alexander John Todt, or Anthony John Todt intentionally procured an act that caused the death of Alexander John Todt. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. Lesser included offenses, count 3, murder first degree, Tyler John Todt. Murder second degree. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tyler John Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was an unlawful killing of Tyler John Todt by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another, demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Tyler John Todt is dead. 2, Anthony John Todt intentionally committed an act or acts that caused the death of Tyler John Todt, or Anthony John Todt intentionally procured an act that caused the death of Tyler John Todt. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. Lesser included offenses, count 4, murder first degree, Megan Denise Todt. Murder second degree. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Megan Denise Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was an unlawful killing of Megan Denise Todt by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Megan Denise Todt is dead. 2, Anthony John Todt intentionally committed an act or acts that caused the death of Megan Denise Todt, or Anthony John Todt intentionally procured an act that caused the death of Megan Denise Todt. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. Principles. If the defendant defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if, 1, the defendant had a conscious intent that the criminal act be done, and 2, the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or a forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the numbers of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2, 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and in the law contained in these instructions. At this point, we're going to take a break from the jury instructions, and the attorneys are going to have an opportunity to give a closing argument. Please remember that during this portion of the trial, what the attorneys say is not evidence or your instruction on the law. However, do listen closely. They are intended to summarize or give you a guide as to what they believe the evidence has shown or failed to show. Each side will have equal time, but the state of Florida is entitled to divide this time between an initial closing statement and a rebuttal closing statement after the defense has given its closing remarks. Ms. Pennell, would you like the podium? All right, thank you, Deputy.
Good morning, everybody. The first thing I want to do is thank you for your time in this case. I know that it's been difficult for all of you to take some time out of your personal lives to be here with us today, and you've all been very attentive, so I would like to thank you for that. The reason why we're here today is control. The defendant wanted control. You heard that December of 2019 started out like every other December for Zoe, Alec, and Tyler. They had a concert on December 6th that they went to. They had an awards banquet on December 14th that they went to. And then everything changed. Sometime between December 14th and December 18th, the defendant took each one of their lives. You heard testimony from some of the 911 operators at the sheriff's office, and you had the opportunity to hear some pretty pleading calls from the defendant's own sister asking for somebody to please go check on the well-being of the family. The first call was on December 29th, and she told law enforcement the family's been sick because that's what she'd been told. They couldn't speak to the family during Christmas because they had the flu. What you learned later is that that was the defendant telling the family that everybody was sick. The defendant was using Megan's phone and Tyler's phone and Alec's phone to tell everybody in the family that they were sick, that's why they couldn't talk to them. But something in the defendant's sister did not sit right. So she called again in January. She called on January 10th. And she insisted that somebody go out and make contact with her brother and the rest of the family. What's interesting between the two phone calls is that in the January 10th call, the defendant's sister tells law enforcement that Megan believes the apocalypse is coming, and she just learned about this information. How did she learn about this information? From the defendant. Because we already know Megan's dead. So, you heard from law enforcement. Law enforcement tried to make contact with the family. Law enforcement went to both addresses, knocked on the doors, the blinds were closed. The defendant had conveniently parked the family van in front of a different building at the apartment on Longview Avenue. The defendant had started using cash and had continued to check the mail to make sure that nothing suspicious was going to lead somebody to the residence. And finally, on January 13th, the defendant didn't come to the door. Law enforcement opened the door, and that's when they discovered everything that was in 202 Reserve Place. And even when law enforcement is there, the defendant is still trying to be deceptive because he needs to keep control. He told Detective Miller something very interesting in his interview. He told Detective Miller, based upon their beliefs, they bring their children into this world, they should get to decide when they leave. The defendant wanted control. The defendant wanted control over the lives of his kids and of the life of Megan. And you heard from the law enforcement officers that found Alec and Tyler and Zoe and Megan. And you heard that initially they could not find Zoe. Could not find Zoe. Ultimately, they found her after looking through the house for 4 or 5 minutes. The defendant at the bottom of the stairs. I don't know when the last time I saw her. I think she went with you. Oh, maybe you should check the garage. The kids went to a sleepover. Megan's upstairs sleeping. The entire time, the defendant is trying to be deceptive. The defendant tells law enforcement also that he was intentionally deceptive with his family so that he could finish what he started. You heard from the medical examiner, and you heard from the toxicologist, and you heard that all of the members of the defendant's family at the time of their death had diphenhydramine in their system, which is Benadryl. You heard that smothering could not be ruled out because of the state of the bodies. If we know that Zoe, Tyler, Alec, and Megan were killed between December 14th and December 18th, law enforcement didn't go into the house until January 13th. It's almost an entire month. The state of their bodies prevented the medical examiner from doing a full investigation during her autopsy, but she was able to ascertain some key important things. She told you that everybody, including Megan, had no signs or issues with their heart or their liver. The medical examiner also told you that based upon the decomp of the bodies, that there was no more liquid blood left. And the boys both had stab wounds, but she didn't see any signs of hemorrhaging, which indicated to her that the stab wounds likely occurred after the death. And the defense attorney is going to get up here, and that is going to be the key point. You can't believe what Anthony Todt told law enforcement in the interview that you saw, because he said and was adamant that he stabbed the children before they died. And the medical examiner got up here and said there was no The stab wounds were post-mortem. And that's why you can't believe Anthony Todt's statement to law enforcement. But how the defendant describes going into each child's room and killing each of his children is consistent with all of the evidence that was found on scene. It's consistent with, the only inconsistency is the stab wound when it occurred. Everybody's in agreement that there's a stab wound. And the defendant's adamant that they didn't die from a stab wound, they died from suffocation. So, what you need to do is really look at the defendant's interview. The defendant very clearly describes how these murders happened. The defendant doesn't remember when they happened, just that they happened sometime before Christmas. That's what his interview said. Now we have some receipts and him knowing that, okay, well, I bought these BB guns after they were dead. So there's a receipt from Academy showing that from December 18th. We know that they were alive on December 14th because of their holiday banquet. The defendant is very meticulous and describes more than one time the order in which each of his children was killed, the manner in which each one of his children was killed, and what he did afterwards. So the defendant told you in his interview, you had the opportunity to see, that after doing some research about the afterlife and considering the fact that Megan was so sick. Megan's so sick, she can't get out of bed, she's frail, she has trouble walking, she's in excruciating pain, all of these things. She had a miscarriage, so she is so much in pain and so depressed that she was looking at these videos of the afterlife and that's the way we're gonna go. So the defendant also tells you in his interview that they sat the children down, including his 4-year-old daughter, and had a conversation with them about this plan, this suicide pact that him and Megan had together. He sat his 4-year-old daughter down and said, what would you do if mommy and daddy died? And then he came to the conclusion that his 4-year-old daughter decided she wanted to die with mommy and daddy. And the same with his 10-year-old son, Tyler, and his 13-year-old son, Alec. Then he had the children gather belongings that were important to them. And you'll see in the photographs, when you have an opportunity to take photographs back there, there is a chest at the foot of the bed in the master bedroom. And on this chest, there's some dolls that you open, and then there's a smaller doll and you open. So that's from Zoe. There is a scarf, a soccer scarf, which is from one of the boys. You'll see a photograph of all three of them with the Cookie Monster. And he displays all of these things on this, almost as if it's an altar. And he tells Detective Miller, I had the children pick out their favorite things so that we could put them there. The defendant then tells Detective Miller that we weren't really sure when we were going to do this, so we made sure we bought some clothes for Alec just in case he was alive. I bought some fishing lures just in case we decided to go fishing before I killed them. The defendant rather nonchalantly describes murdering his children. And on the day that he does this, he tells law enforcement, and you got to hear it, that set an alarm for 11:30 p.m. so that he could wake up to accomplish.
Objection, fact's not in evidence.
I see the attorney's objection. Overruled. You may continue.
Specifically, the defendant said, woke up at 11:30 at night, we set the alarm for 11:30 at night and got up out of bed, and it was Zoe first. That's what the defendant said to Detective Miller. The defendant then describes going into Zoe's room, and he describes laying there for a little while, getting up his courage. And ultimately, he rolls over on top of Zoe, and you saw how the defendant looked in his interview. That was approximately a month before or after the death. So that size is accurate as to what his size was at the time. And you heard the medical examiner talk about the weight of Zoe. And the defendant rolled over on top of her and suffocated her. And he described that this took about 15 minutes, but she really only kicked and screamed for about 3 or 4. The defendant then said, I put some covers on her so that she would stay warm. And I want to point out the fact that he talks about that in his interview, because yesterday you heard him say, when Megan told him that she killed the children, that he goes to Zoe's room first, because everything is in the same order. So he goes to Zoe's room first, and he goes and gets a wash rag, and he goes back and he closes her eyes and shuts her mouth with the wash rag, because it's the fatherly thing to do to make sure that she's comfortable. That's what the defendant told you yesterday. Now, after he's done killing Zoe, the 4-year-old, he goes to Alec, and Alec is upstairs. Alec is the 13-year-old boy. Alec's the oldest. He also described on the stand yesterday that Alec's the strongest. And he goes and he suffocates Alex. And how he describes it to Detective Miller is also very nonchalant. And he also indicates to Detective Miller that he stabs Alec in the abdomen. He's looking for the umbilicus or this vein that is supposed to help Alec bleed out quickly. Then the defendant goes downstairs to Tyler. Conveniently, Alec and Tyler are separated. They share a room. You had an opportunity to see the photos. Their beds normally are close together, but conveniently on this night they are separated. And Tyler's downstairs on the couch. And I made sure to ask the defendant yesterday, was it a pull-out couch? Was the couch open? You know, what was going on with the couch at the time that Tyler was killed? So not only did the defendant go in there and suffocate Tyler and stab Tyler's body, But the defendant, after he moved Tyler, took the time to put the couch back, put all the cushions back on the couch, make sure everything was all organized and put away. There was a stuffed animal sitting on the couch. It looked undisturbed. Now, then after all the children are dead, the defendant decides, with Megan, according to his statement, that he's going to kill Breezy. So they put a blanket down on the master bedroom bed. They call the dog up onto the bed, and the defendant grabs the dog's snout and suffocates the dog and kills the dog. The defendant then wraps the dog in a blanket, puts it in a dog bed under the nightstand. And it was at this point that the defendant does describe this plan, and Detective Miller specifically asks him, if you had everything so planned, if this was the plan and it had to happen, and this is what you were going to do for the afterlife, why didn't you know who was going to die first? Why was there a question as to who was going to die before Megan or the defendant? The defendant then tells law enforcement that Megan stabs herself, not once but twice. And there's a bit of time between each stabbing where they're laying in bed hoping that Megan's going to bleed out and die. And the defendant is very detailed in describing everything that happened between each stabbing. The defendant says that Megan was getting aggravated because it wasn't working. She was chugging Benadryl, she was chugging wine, she was taking Tylenol PM, she was doing all of these things in an attempt to kill herself. And you heard from Dr. Nora yesterday that, actually 2 days ago, that none of the stab wounds were fatal. And ultimately, the defendant takes a pillow and puts it over Megan's head until she dies. Now, something that I want to point out to you about his testimony yesterday, because the defendant says yesterday that he came home, Megan said she killed the kids, he went and checked on each kid, and then Megan stabbed herself. And at some point, he's given her CPR. You heard from the medical examiner that the stab wounds weren't fatal. He jumps into CPR. He says the cell phones are hidden, but he doesn't call out for help. He doesn't try and get help. He describes the situation that he just comes home and all his children are dead. It's morning. And when I asked him specifically, well, did you go to a neighbor? Did you try and get help? He says, well, we live in a snowbird area, right? It was December. It was December. This would be prime time for everybody to be at their houses. It's the morning, it's unrealistic to believe that there was nobody there. And also something that's very interesting about what the defendant told you yesterday is how he described Megan. When the defense was questioning the defendant was very emotional. describing Megan. He was describing himself as a very loving and devoted husband. He would do anything for his wife. And it made him choke up as he's describing this to you. And he was very detailed, used a lot of adjectives. But you also got to see a different side of the defendant yesterday. The defendant did not shed one tear when I was talking to him. In fact, he was pretty angry with me. And I had him describe going into each child's room and finding his children dead, something that he did not talk about on direct examination. And he was just angry. And something else that I'll point out to you is he described himself as this loyal, I'll do anything, I'll take the blame for Megan man. But something very interesting that he said is Megan killed her kids. Megan killed her kids. Not our kids, not my kids, her kids. And something also about what he says, because he kind of changed his statement. And the judge is going to tell you, well, he did tell you, that you have to look at the defendant's statement yesterday, just like you would every other witness. You have to weigh what he said with the other evidence that you have in the case. You also have to weigh his statement within it. Is his statement consistent with the rest of what he's telling you? Is his statement consistent with the evidence? Is his statement consistent? Well, we know it's not consistent with what he told law enforcement, right? So some of the things that he told you yesterday, he told you when he had first got home, Megan's shirt's covered in blood. What happened? He just came out of the bathroom. What happened? And he runs and he checks on Zoe. Right? So Megan just told him, I killed our kids. This is why, because the afterlife, and she's trying to explain to him, and she's following him around because miraculously on this day, she was pain-free. Every other day of her life, she was in enough pain to kill herself and her children, but this day she was pain-free. So she's pain-free, running after him as he's checking on her children. He runs past Alex's room to Zoe's room. Because Zoe's his princess, that's what he said yesterday. He sees Zoe and goes to the bathroom, gets a washcloth and closes her eyes. Meanwhile, he's been told his other two children are dead. He doesn't go from child to child to child. He takes the time, he goes to the bathroom, gets a washcloth, wets the washcloth. He tells you yesterday, well, I didn't have a chance to wet the washcloth between each one. Does that make sense to you? Something that's great about being a juror is you don't have to check your common sense at the door when you come in. You get to bring it back with you in deliberation, or you get to bring it in here. And the defendant says after all this, Megan's following him around and he tells her, I just want you to get help. I'll take the blame. I just want you to get help. Because he's got to explain why he told law enforcement he did it. So I'll take the blame. And then after she stabs herself and he tries CPR, then that's when he yells out the window, but nobody answers. The defendant sat in that house for over 3 weeks with his dead family. The defendant, although he denied it yesterday, told law enforcement he went to Sarasota after they died. He's going to Academy. He's going to Publix. He's going to CVS. He's going to Walgreens. He's going to all these places, using cash at all these places. He's checking the mail. He's pulling in packages. And his family he had moved them all to the same room. He put rosaries in all of their hands. He covered them all up with blankets. He's also putting a lot of plug-ins. There's candles in the trash. There's air purifiers that are stacked in this room. And he is living in this bedroom with his dead family. And he tells you, the whole time, I was just trying to get the courage to kill myself. He had the courage to kill his 4-year-old daughter. So he tries hanging, and you saw a picture of the ratchet strap. He tries zip ties that he tied around his neck, that he cut off, that he conveniently left out in the open. He tries BB guns. He tries Benadryl. He tries all these different ways to kill himself for 3 weeks. And he also takes the time to write a typed note to leave it in case, and you'll get it. You didn't get to read it in here, but you'll get a chance to read it when you deliberate, because the note's in evidence, so you'll get a chance to look at it. And during his interview with law enforcement, he uses the word "we" throughout the interview. And something that he said yesterday is he's going to take the blame. He loves Megan. He's loyal to Megan. He's a loving husband, a loving father. You know, he takes every opportunity to play with his kids because he doesn't know, when will be the last opportunity. He included Megan on everything he told law enforcement. It wasn't, I take the blame, she didn't do anything. They did it together, is what he tells law enforcement. He is the one that carried out the killings, but she's in the doorway encouraging him. There are a lot of things within his statement he said to me yesterday that are inconsistent. He describes in detail the fact that they had leftovers for dinner. The kids ate, but he didn't eat. He had a shake. He then, after dinner, gets in their family van and drives over to 211 Longview. Realizes he forgets his tools, so he walks back to 202, plays basketball with his kids. He doesn't know. The sun's still up. He didn't tell me a time. Sun's still up. He walks back with the bag of tools to 211, realizes his phone's about to die. So he sits in his van and charges his phone. But when I specifically asked him if he had a phone when he found out his family was dead, he said, well, I fell asleep in the van, but the van wasn't on, so the phone didn't charge, and I didn't know the phone didn't charge. When you plug a phone in, you know whether it's charging or not. And the defendant wants you to believe that he slept an entire night in this van with it off. So the defendant wakes up and he realizes he's late and he's got to get back because he doesn't want his wife to be mad because he's got to do these physical therapy moves on her to help her. So he rushes back, but he leaves the van there and walks back. And he goes in the house, and that's when he discovers all of this thing. And something else that you can consider is whether the witness was straightforward in answering attorney's questions. The defendant, I told you, we're here because the defendant wants control. The defendant tried to control everything yesterday. Too. I would ask a question, the defendant would give an answer that he wanted to give, and then we would have, it's a yes or no question, and there was a lot of back and forth between both of us. The defendant was trying to ask me questions. He wants control. The state's burden, as the judge told you, is beyond a reasonable doubt. The judge told you that it's not a possible doubt, speculative doubt, imaginary forced doubt. It's a reasonable doubt. And we talked in jury instruction and jury selection that there's a difference between what's possible and what's reasonable, right? So how you can find a reasonable doubt, if there is one, I submit to you that there's not, is the evidence, a lack of evidence, or conflict in the evidence. The conflict in the evidence comes from what the defendant told you yesterday. Because obviously he gave one complete statement to law enforcement and a completely different statement to you in court yesterday. The two cannot be resolved. So you're going to have to decide which version you believe. I submit to you that what the defendant told law enforcement makes the most sense in this case. The defendant took the life of Zoe. He then went and took the life of Alec, then Tyler, then the family dog, and then ended with his wife. And now we're here. The state's confident that you're going to return verdicts in this case.
Thank you, Ms. Minnell.
Judge. You need a minute? May it please court, counsel, members of the jury. Good morning, and thank you. Thank you for the sacrifice of your time. Thank you for the attention that you've paid throughout the course of this trial. You've sat through several days of testimony, several days of evidence, and now based off that evidence, the state is asking for a conviction, but not the defense. No, we're asking that you take all the evidence, all the testimony into consideration, and return a verdict that is based off that evidence, that's based off that testimony, a verdict of not guilty. You've heard a lot, you've seen a lot, but you also haven't heard a lot, and you also haven't seen a lot. There are holes, there are gaps, and there's reasonable doubt. Now, the things that you're left with here, the things that weren't done, and what doesn't make sense, that gives rise to reasonable doubt. During jury selection last week, you heard that, and you've heard throughout the presentation of the case, and you have those jury instructions that Judge Carson was going over, that the state, because they're bringing these charges, they have the burden of proof. They have the burden to prove the case beyond and to the exclusion of a reasonable doubt. Now, that burden of proof not only applies to the case as a whole, but it applies to each of the charges that Mr. Todt sits here for today, for the deaths of each member of his family as well as the family dog. Now, members of the jury, the state hasn't met that burden. You've heard the evidence, you've heard the testimony, and the evidence and testimony that has been presented throughout the several days of testimony have not proven the case beyond a reasonable doubt. Now, a reasonable doubt is not a mere possible, speculative, imaginary, or forced doubt. A reasonable doubt is a doubt to which a reason can be attached, and we have that here. Not in an insensitive sort of way, but in a way that's the truth. Now, the judge instructed you on the elements, and you have those instructions with you. Now, when it comes to a reasonable doubt, it can come from the evidence, a lack of evidence, or even a conflict in the evidence. And specifically, the definition for the reasonable doubt, the jury instructions, is that it's not a mere possible, speculative, imaginary, or forced doubt. However, if after considering and weighing all the evidence, there's not an abiding conviction of guilt, or if it wavers and vacillates, then the charge has not been proven beyond a reasonable doubt, and the state hasn't met their burden, so you will have to find Mr. Todt not guilty. Now, like I said, a reasonable doubt, it can come from the evidence, it can come from a lack of evidence, it could even come from the conflicts in the evidence. And I'm going to take time to kind of go through each of them and show you where I believe, or where the defense believes that there can be a reasonable doubt. Now, you've heard from several witnesses throughout the course of this trial, and you've heard from Mr. Todt as well. And in some regard, each of those witnesses in some way has some interest in this case. And that's one of the factors that you can look at in determining credibility. Now, we've heard from law enforcement, we've heard from medical personnel, we've heard from toxicologists and forensic technicians, those who are alleging the charges, who are part of the state, who are bringing the charges. Now, this case is ultimately a product of their work, their investigation, and their analysis. And they're asking for and seeking a conviction, but what they want and what the evidence has shown, they're two different things. The state hasn't met their burden throughout the days of testimony. And you've heard as well from Mr. Todt, both in the interview as well as in him testifying yesterday throughout the case. Now, you also heard when we talked about that Mr. Todt has the absolute right to remain silent. He has the right not to talk, not to testify, but he chose to do that. Now, in looking at the evidence, let's turn first to there. Now, one thing that the state said, and I'm going to agree with them, they said that the defense is going to harp on the medical examiner's report regarding the blood. And that's right, because that's one of the places that you can find a reasonable doubt in the evidence. So in terms of the medical examiner, Dr. Nara, now, Dr. Nara indicated that she did the autopsies for each of the members of the family, starting first with Zoe. And she indicated that in terms of all of the members of the family, there was that Benadryl. And that she couldn't identify or specify that it was or was not a cause of the death. She indicated that there was the homicidal violence of unspecified means that also was in connection with that Benadryl. Now, she wasn't able to determine if there was smothering or if there was a strangulation or anything of that nature in terms of each member of the family. So if the medical examiner can't rule out and give you the true cause of death, that goes towards reasonable doubt. Now, in terms of Alex, she also indicated that homicidal violence of unspecified means with the diphenhydramine, the Benadryl. In Tyler, she also indicated the same thing. And even in Megan. Now in Megan, in addition to the dihydrohydromonethane, she also indicated that there were stab wounds. Now, in terms of Zoe, Alex, and Tyler, she indicated that while there were stab wounds, there was no hemorrhaging in the abdominal cavity, which means that the stab wounds were post-mortem. Now, in terms of Megan, there were the two wounds. They were about 8 inches deep and about 1/4 of an inch apart. Now, she indicated that there was hemorrhage inside of Megan's abdominal cavity and that there was clotted blood in the soft tissue. And she indicates that those indicate that the injuries were sustained while she was alive. Now, she also indicates that in terms of Megan, in addition to the Benadryl, that there also was some ethanol, some alcohol potentially. Now, Dr. Nara, when she initially was doing the autopsies, Detective Cross told her that this was a case of strangulation. And in doing her medical exam and in doing that external exam as well as that internal exam, she wasn't able to confirm that and she wasn't able to deny that. Now, she talked somewhat about kind of Benadryl and kind of how it worked a little bit. But she also talked about the incisions. She talked about the Y and the L incision and how, specifically in Megan, being that that stab wound did occur before death, typically the incision wouldn't be straight like what we had in this case, if the person was moving or if there was a hesitation. There was none of that in this case. She can't say who did this cause a stab wound, but she also did testify that if a person moved, that would cause that L or potentially that Y incision. And we didn't have that in this case. Now, Dr. Nara also talked about some of the things that she collected and ultimately ends up sending off to toxicology because of not being, basically toxicology request, hey, there was no blood. These are some things that we can use to determine levels and things of that nature. So she collected those samples from the brain, the liver, and chest fluid if it was available in terms of each of the members of the family. Now, the Benadryl, the toxicity of that, she indicates that it was homicidal violence, but she also defines what homicidal violence means. It just means the act of another person. And she specifically indicated that homicidal violence does not mean premeditation. Now, in terms of the examination following that, basically the toxicologist that was done, Dr. Nara did indicate that there was some strangulation and asphyxiation as well. And she was told about this possible suicide note and suicide pact. Now, Dr. Dare did tell you that Benadryl, it can be toxic. Yes, it's an over-the-counter medication. It can be used for sleeping and for itching. But if it's taken as prescribed, there are no toxic effects. However, if it's taken in higher doses, it can cause cardiac issues, especially in children. It can cause it can in some cases also cause death. Now, she's been involved in about 12 other Benadryl autopsies where those were suicide cases, but while she said it's rare because people typically might choose other drugs or narcotics, Benadryl could be used to not only commit suicide or cause overdoses. Now, she did consider strangulation because in strangulation cases, it will cause possibly the heart to stop. But she wasn't able to rule out strangulation due to the decomposition. Now, the depth of the knife wound, she also indicated, was very important because specifically a Y wound for a knife would indicate a thrust, whereas an L wound for a knife indicates that the person's being stabbed or the person doing the stabbing, if they're stabbing themselves, move the knife. We had neither a Y incision or an L incision here. Now, Dr. Nara also talked about how the brain can be a good source of information. And specifically in terms of Megan's brain, there was that ethanol, which she believes means that there was some alcohol consumption before death. Now, the knife wound on Megan, she couldn't tell, like I mentioned, if it was self-inflicted or not. But she did indicate that with a knife wound for a potential suicide or stabbing, she looks to see the location to make sure if it's something that they can inflict themselves. And in this case, we have an abdominal, two abdominal wounds that are about 3/4 of an inch apart. Now, there was no trauma, and if there was trauma, that would be something she would look for because she indicated the trauma would be indicative of if there were signs of a struggle. There was none of that here. She also looks potentially for injuries to the mouth, because if there was injuries to the mouth, then she might have done an exam or something to the mouth to look for that. In this case, no injuries were observed to the mouth, so she didn't cut into the mouth to look for it, which could have been caused by punching or being smothered with a pillow. None of that was observed here. Now, based off of the medical exam that was conducted by Dr. Nara, she also collected those samples that she sent to the Stewart laboratory, where Ms. Carswell, the forensic medical technologist or toxicologist, conducted the toxicology, drug, and alcohol testing. Now, the specimens she received all came from the medical examiner's office. There were the brain tissue, the chest fluids were available, as well as the liver tissue. Now, she told us some various different numbers in terms of milliliters per kilogram and things like that. But the most important thing was that the dihydroaminophene, was found in each of the kids. It was found in Zoe, it was found in Alec, it was found in Tyler, as well as in Megan. Now, based off of this, as well as in Megan, there was also that ethanol level. And basically, while they do these toxicology tests, these are things that FDLE could have potentially done as well, because FDLE does have some alcohol testing and some other things, which many other things went to FDLE, because we heard from FDLE analyst, Mr. Conklin. Now, there was no heavy metal testing and there was nothing else that was done, because Ms. Carswell was acting essentially at the direction of Dr. Nara. And Dr. Nara was getting her information from Detective Miller, who was getting his information from Mr. Todt. Now, we also heard from Dr. Stern, who was the veterinarian, and he talked about the necropsy, or now the medical change is changing to autopsy as well for animals, to the autopsy that he conducted on the canine. Now, he indicated that the canine was severely decomposed, but he also indicated that there was a dental disease and a collapsing of the trachea within the canine, within Breezy, that was found. And Dr. Stern couldn't tell you how Breezy died. He couldn't indicate a strangulation. He couldn't indicate a suffocation. And while there was a wound, he can't say that that wound was a stab wound. Based off the position in which Breezy was found, he indicated, because of her being upside down, that could have easily been just a cause of decompensation. We also heard from the forensic toxicologist, Dr. Goldberger. Now, he deals with this Benadryl toxicity on a regular basis. Essentially, his whole practice at the University of Florida and the autopsy that he does is specifically on Benadryl toxicity. Now, he looks at toxicity, he looks at overdose, he looks as well at fatality. Now, in each of the brain and the liver tissues that were tested, it was found to be present. We heard that from Dr. Nair, we heard that from Ms. Carswell as well, and then we also heard it from Dr. Goldberger. Now, in his examination, this is what he does primarily on a day-to-day basis, like he said, pretty much all day, every day, whether it's doing research or doing actual testing, he's dealing with Benadryl toxicity all day, every day. And he has been for several years. Now, he indicated that he can't say that it was or that it wasn't the toxicological cause of death. He indicates that the levels were remarkable, which means that they weren't insignificant, they weren't incidental. There's something to note, there's something to look for. They were remarkable, which indicates it's a higher level. It's abnormal. It's not a normal amount. Now, there was a finding of toxicity in each of the kids and as well as in Megan. Now, we have the medical examiner who can't say that strangulation or suffocation was or wasn't the cause of death. We have Dr. Goldberger who can't say that Benadryl was or wasn't a cause of death. So while we have an unnatural death, we can't even say what caused the death. So yes, the state is right. The defense is going to focus on that because that gives rise to reasonable doubt. That means they haven't proven the case beyond and to the exclusion of a reasonable doubt. Now, even in terms of Breezy, I know we don't necessarily have Benadryl levels or anything like that in terms of her, but that's still something that you can look at. Dr. Stern, the veterinarian, can't say what the cause of her death was either. Now, we also heard from several different law enforcement officers who arrived to the scene following well-being checks and things of that nature. Now, specifically on the day in which they made contact with Mr. Todt, they indicated that they didn't knock on the door, they just walked in. And when they walk in, they see him at the top of the stairs. And he's shaking, mumbling, incoherent, kind of stumbling as he makes his way down the stairs to ultimately talk to them for several minutes. He says he thinks Megan's upstairs sleeping and things like that. Now he sits on the bottom stair, which is an interesting point because he sits on this bottom stair, and we saw that in the body cam video. But then later, the forensic technician, Ms. Seda, does a walkthrough of the house and finds evidence, specifically finds a receipt on this same bottom stair where Mr. Todt sat for a minute or two and talked to these various officers before he was taken away to the hospital and everything. We also heard, in addition from these various officers who initially observed Mr. Todt at the time that they arrived to that house on the 13th and made contact with him before the bodies were ultimately discovered. They were the ones who initially saw him, who interacted with him, who were able to talk about the shakiness, the incoherentness, the way in which he was talking and mumbling and not really making sense. And after that, we also heard, like I mentioned, Ms. Seda. We heard from the forensic technician. Now, Ms. Seda responded, and she was the primary technician at the case in there. She did most of her initial processing on the 13th, but she did end up coming back on the 15th to do additional processing at the direction of Detective Miller based on his interview with Mr. Todt to look for other items of evidentiary value. Now, Ms. Seda, she indicates that she did that initial walkthrough of the house, but when she got there, there were numerous law enforcement. She wasn't really sure exactly how many, but there were several law enforcement that were on scene. They did a walkthrough with her, and they were to point out anything of importance or anything that maybe for her to focus on. They pointed out nothing. Including the receipt that was supposed to be on this bottom step of the stairs where Mr. Todt sat and talked to the men. Nobody pointed it out. Nobody saw it, but we walked by it. Now, Ms. Seda did various processing. There were photos entered into evidence that what she photographed and processed. Now, she indicated that she photographed a lot. She processed a lot. Now, she initially began the documentation with the exterior of the home and then makes her way into the home. She indicates that the downstairs area of the house, clean, orderly, no issues, doesn't seem disturbed at all. She talks about the kitchen being clean and minus the trash that she collects from the kitchen trash can, as well as that downstairs bathroom in the downstairs area of the home. She talks about seeing some wine bottles and things like that were photographed but not ultimately processed or collected. And just remember that Megan, that she had alcohol in her system. So there was no testing done on this bottle to indicate, was there something inside of it? Was there not? Whose fingerprints are on the bottle? Because we later hear from Mr. Conklin a lot about fingerprints that came back to Anthony, to Mr. Todt. Now, Ms. Seda does the initial documentation of downstairs and then she makes her way upstairs. And then upstairs she photographs and documents as well up there. Now, in the downstairs bathroom, before she gets upstairs, she notes that basically these Glade air freshener type plug-ins that are in that downstairs bathroom. Now, in terms of going upstairs, she photographs kind of the railing on the way up, and we see Benadryl bottle there and a phone. And throughout the time of her collecting, she sees adult Benadryl, children's Benadryl, liquid Benadryl, Benadryl tablets or pills, and even some Waldryl ultimately outside. Now, she can't really say, she thinks it was about 8 bottles total that she ends up collecting total of Benadryl. Now, the knife, and she collects various items. She talks about like 2 knives that she collects, the 2 BB guns, the knife sheath, I want to call it a ratchet strap, but the strap that she collected and some other items. The house was fully processed. The entire home was fully processed. She talked about a lot of things that she collected, but we didn't see necessarily everything. That she collected, because she also mentioned collecting some journals and some notebooks and things like that as well. She indicated that she also processed the ottoman, the note that was on the ottoman, the suicide note that the state was talking about earlier, and she was able to get prints off of that. Now, we didn't hear any testimony about any prints or whose prints were actually on this note or anything like that throughout the course of the testimony from Mr. Conklin or Ms. Sada, who was the one who kind of compared the prints and did the lift cards. Ms. Sada was the only forensic technician that went to the Longview Avenue address. And that was after she left the reserve place. So the reserve place is where Mr. Todt was initially, and then they go to the Longview address. She processes that area as well. She did another walkthrough with law enforcement. There was nothing really particular found at that location. No bit of drill or anything like that. They talk about collecting the van, processing the van, all of that. But there was no print collections that were done for the van. But on the 15th, like I mentioned in the beginning, she kind of goes back to the reserve place, to the main home, based off of the directions of Detective Miller. And at this point, the main focus is on the master bedroom. And at this point, based off of the interview, the detective is like, hey, look for these zip ties, look for this knife, look for, the red strap, these different things. Look for these BB guns, things like that. Now, we hear a lot about things that were collected, and the detective makes a point of pointing out and asking Mr. Todt, like, where did you get this from? Where did you get that from? What's the passcode for this? Which device were you using to search for it? Now, that leads to lack of evidence. We hear him ask him all these questions, but we don't hear anything that Detective Miller does with this information. We don't see any phone searches. We don't see any Google searches. We don't see any The state talks about premeditation. How he planned this, but there's been no evidence or documentation to prove it. If we're going based on the fact that Mr. Todt said that they researched it all this time, Detective Miller is asking him, well, what's the passcode? Well, what device was used? Did you use this phone? Where did you find this at? When did you go do this? We see nothing to back up any work that Detective Miller did to corroborate this information. Detective Miller took Mr. Todt at his word and decided, hey, my job is done. But deciding that your job is done doesn't mean that the state has proven the case beyond a reasonable doubt. What was done and what wasn't done gives rise to reasonable doubt. The blood on the knife, I think it was the black and green, the buck knife. The blood on the knife was collected, but I don't believe they indicated it was tested. And the state talks about, like, they made a point of pointing out this bleach bottle. Ms. Seda said there was no indication to indicate that the bleach bottle was used, that no cleanup was attempted to be done, or anything like that. The state also indicated, once again, that the downstairs area was clean. There was no blood on the stairs leading upstairs. There was no blood downstairs in that library nook room. There was nothing down there. Now, Ms. Melendez, another forensic technician with Osceola, she went to the hospital on the 15th and she took photographs of Mr. Todt. She took photographs of various injuries. You were able to see the photograph of him.
Yeah, come on.
Ms. Melendez made contact with Mr. Todt at the sheriff's office following his release from the hospital while he still had those EKG, ECG nodes on his chest and his abdomen. And she documented injuries to his hand. You can see a Band-Aid. She documented wounds on his left chest and on his abdomen. And she also took some prints from him. And then ultimately collected the swabs as well. Now, in terms of Mr. Conklin, the FDLE analyst who kind of took all the DNA that was collected by either Ms. Seda, Ms. Melendez, or the fingerprint cards that Ms. West collected, and he did the comparison of those. Now, Mr. Conklin indicated that the swabs were collected from both of the knives, and basically the swabs on the handle were consistent with being from at least three donors, at least one of which was male. Because of the fact that he had basically full profiles, those fingerprints for each member of the family, he was able to indicate that each and every one of the members of the family touched the knife that was found in their house. But he can't say when the DNA got there, how the DNA got there, how long it's been there. We hear about the fingerprints that were collected from the knife and the different items, but we don't hear anything about any DNA. We know that Zoe, Megan, and Alec as well as Tyler were all stabbed. The only wound that was post-mortem, or excuse me, anti-mortem, i.e. before death, was Megan, because she's the only one that had the blood in the cavity that would indicate she was stabbed before. We've heard no testimony about any of the blood on the knife being hers. We've had no testimony of the blood on the knife being any of the other children. Now, we've kind of gone through a rough overview, and I know throughout the course of trial you guys were taking notes as well, so you have that to rely on as well. So we've gone through a general bulk of most of the evidence. Now, let's turn to the lack of evidence, and I've kind of pointed out some of that as well. We have these photographs of these receipts and these things. And while the state doesn't have to put forth a specific number of a specific amount of evidence, we haven't seen anything that was substantiated, like I was saying with Detective Miller. He's asking all these things about when did you do this? How long have you been doing this? For the state to try to tie it to premeditation. But we've seen nothing that would substantiate premeditation. There was a lack of evidence in terms of any disturbance from downstairs. There's no blood downstairs. There's no disturbance. The state made sure to point out that that room was neat and in order. But according to Mr. Todt's interview with law enforcement, he supposedly carried Tyler from downstairs. And according to him, Tyler is the quick one, so he had to be quick with the movement, and there was blood everywhere. But there's no blood in that room. There's no blood trailing up the stairs. There's no blood anywhere in the home except the master bedroom. And really, there's no blood technically anywhere, because the medical examiners indicated like basically all the blood had left. There was no blood in the body. So the only bedroom that has blood potentially is the master bedroom. There's no blood on the stairs, no blood in that library room. So how, if you believe Mr. Todt's statement, how was he able to stab Tyler, the quick one, and he indicated in his statement that there was all this blood, and carry him upstairs little by little over his shoulder with no blood dripping from that room through the stairs, up the stairs, ultimately into this master bedroom. That lack of evidence and that conflict in the evidence doesn't make sense. The state wants you to believe Mr. Todt's statement that he gave to law enforcement on the 15th after being released from the hospital. And they don't want you to believe what he told you about yesterday when he testified. Now, in terms of statements, there are in the jury instructions that you have some things that I want to point out. First, in terms of, like I was talking about, the premeditation, it has to be a conscious decision to do so and must be present in the mind at the time of the killing. The premeditated intent to kill must be formed before the killing. So the state is using all this, and Detective Miller is using all this. You've been planning this for all this time to go towards premeditation, but there's nothing to really substantiate the premeditation. Specifically, the state has to prove that Mr. Todt was the one that did these things. We've heard his testimony, and we've heard the testimony both in terms of his interview as well as yesterday about how basically it was Megan. It was Megan's idea, and as the father of the house, he's essentially taking responsibility for it. But taking responsibility for it doesn't mean he was the one that committed the act, and doesn't mean he was the one that did it. Just because he's taking responsibility supposedly after the fact doesn't change the person who committed the acts in the beginning. Now, in Mr. Todt's statements, he talks about stabbing each of his kids. His statement is that each and every one of these occurred before the suffocation before the death. His testimony and statement to law enforcement was that there was a stabbing prior, and then there was either suffocation or strangling after that. So essentially, stab, suffocate, strangle, death. But that doesn't coincide with what the medical examiner said. The medical examiner said that each of those stab wounds occurred after death, or there would have been blood in the cavity. So the state is essentially having you pick and choose when they want you to believe the defendant's statements and when they don't want you to believe his statements. They want you to believe that he did it, but don't believe the way he said he did it, because it contradicts the actual physical evidence from the medical examiner, from the toxicologist, and from Dr. Goldberg as well. Now, the lack of evidence and conflicts in the evidence, like I said, they kind of go together. Now, in terms of the weighing the evidence, let me go first to defendant's statements, because the state is essentially, like I said, pick and choosing when they want you to believe what Mr. Todt says and when they don't. Specifically, that instruction says, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowing, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether, when the defendant made the statement, he'd been threatened in order to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Now, You're supposed to consider his statement, and you make that determination from the evidence. So while his statement he did it helps the state's evidence, his statement of how he supposedly did it completely contradicts the physical evidence that we have in this case. What we have is Mr. Todt taking responsibility and saying that he did it after the fact, not before and not during. After all of it was done, after his family is now deceased, he's now taking responsibility to protect Megan, to protect the family, even in death. The state can't pick and choose when they want you to believe his statement. Believe that he did it, but don't believe the way in which he said it did it, because it contradicts the actual evidence. Now, the state talked about how Mr. Todt was upset and crying during direct examination, but when she questioned him, he lost all tears. When she questioned him and was telling him, give me a yes or no, when he asked, can I explain? When she's questioning him and telling him, I want a yes or no, when she's questioning him and cutting him off when he's trying to answer the question and explain. He told you he's waited 2 years to be able to tell his story and to be able to talk. And now she's cutting him off and not allowing him to do so when he's trying to answer the question. He even asks sometimes, like, do you want a yes or a no, or can I explain? And she picked and chose when she was willing to let him explain and when she wanted a yes or no. Just like she wants to pick and choose when she wants you to believe. His statement. Now, we've talked about the evidence, we've talked about the lack of evidence, we talked about the conflicts in the evidence. And there is the credibility factor that you're allowed to look at and that you should look at, because like the state said, you don't leave your common sense at that door when you go